Well. Good morning-ish slash afternoon. I don't normally come on and do lives, and I guess I feel like I need to come on and talk about my case and share my my case summary with you guys. Now, it might sound like everything's all over the place, but it's all in order. Excuse me. So, my 4 sons were taken by Child Protective Services in Arizona and Oklahoma beginning in 2009, resulting in a 10-year plus battle. Me and my mom continue to fight to bring light on the Department of Child Safety, their fraudulent, perpetuated, deeds that they do to families. I don't normally like doing interviews by myself because I always freeze up and I worry, am I going to forget something, or maybe I don't know, or maybe I don't remember. And one of my safety mechanisms or tools, is I put everything that's happened in a box and store it somewhere. But anyways, bear with me. On May 4th of 2009, my first son, Isaiah Johnson, was seized at age 14 months old. The allegations were medical neglect. On October 12th of 2009, my second son, Wilfredo, but he took his dad's name, but I call him Freddie. He was seized directly from the hospital at 14 days old because the state took Isaiah, my first. On June 6th of 2011, Josiah Johnson was seized directly from the hospital in Oklahoma at 3 days old because, once again, Arizona took my other 2. On February 5th of 2014, my youngest son, Jaden Johnson, was seized at 7.5 months old because Arizona seized my older 3. Now, this is in violation of ARS 8-821A, which says the child's sibling shall also be taken into temporary custody only if reasonable grounds independently exist. So, the medical malpractice cover-up. On March 24th, 2008, I was admitted to Arrowhead Hospital to have my labor induced. On March 25th, 2008, my water broke. Or it was broken. They broke it, I guess. I don't really remember. On March 25th, 2008, my OBGYN, which was Dr. Dawn Jenkins, I was at Arrowhead Hospital, and this is where the medical malpractice began. So the hospital, this says, hospital records indicate mother's OBGYN, Dr. Dawn Jenkins, ordered Pitocin, which, Pitocin is to induce your labor. And, however, Dr. Dawn Jenkins left the hospital to deliver another baby at another hospital. When Dr. Dawn Jenkins was delayed in returning to Arrowhead Hospital to deliver my first son, Isaiah, she ordered for the hospital to give me terbutaline sulfate to stop my labor. Terbutaline sulfate and Pitocin I was being given at the same time. So my body was going into shock. Didn't know whether to stop my labor or to keep going. The cord was wrapped around my son's neck twice, which resulted in him having cerebral palsy. On March 26th of 2008, Dr. Jenkins decided to perform a C-section to deliver Isaiah. The child, my son, was deprived of oxygen. The umbilical cord was wrapped around his neck twice, and he began having seizures and was eventually diagnosed with cerebral palsy, which is a birth injury, when he was approximately 7 months old. One of the most commonly used drugs in childbirth is Pitocin. Pitocin isn't without its risks to both the mother and the fetus. Here, I'll give you a quick list of the side effects, the known side effects. Retinal hemorrhage, cerebral hemorrhage, which is bleeding within the brain tissue or ventricles. Neonatal jaundice, brain damage, including hypoxic ischemic encephalopathy. Lower APGAR scores at 5 minutes, neonatal seizures, and death. On March 26, 2008, approximately 7 hours after Isaiah was delivered by C-section, Dr. Dawn Jenkins maliciously attempted to cover up her medical malpractice by contacting a social worker at Arrowhead Hospital. LC, I'm assuming that's licensed social worker Patricia Janicki, Janicki. Forgive me if I pronounce any of these words wrong. So it says social worker was referred to patient by Dr. Jenkins for emotional support. And like it says, to see the exhibits and stuff, but, and I have no problem sharing that. So anyways, on May 20th of 2008, I took Isaiah to Phoenix Children's Hospital over concerns about his health, and he was admitted for 5 days. On May 24th of 2008, Phoenix Children's Hospital social worker consultation notes Jackie Swigert, Swigart, suggested to Dr. Carter that mom is to be observed during nesting, and if there's any issues of concerns, or if she, meaning me, the mother, does not show up, then social worker could consider CPS referral. It says mother was bonding well and was present. So financial incentives and illegal contracts. Arizona CPS has a contract with Phoenix Children's Hospital, whereas PCH makes a profit of $865 for every child they refer to CPS. Additional contracts incentivize financial profits up to $5,920, which violates Stark's Law. September 30th, 2008, Isaiah was diagnosed with brain damage, which is hypoxic ischemic encephalopathy and cerebral palsy. December 6, 2008, Susie James, which is a CPS social worker, child safety assessment states, data shows that Isaiah was seeing 2 pediatricians, 2 neurologists, and an eye doctor at this moment, as well as going to Phoenix Children's Hospital. He was also registered with DDD and Healthy Families, who will be providing him services. Keep this in mind, okay? May 3rd, 2009, CPS workers Jennifer Hagan and Rhonda Cash issued 2 predetermined notice to providers. Now, this is on May 3rd, okay? One to Dr. Demoplin, a pediatrician at Twin Pediatrics, and he was also, when I was a kid, he was my pediatrician. And one to Dr. Janet Teodori, which she was a neurologist. One of Isaiah's neurologists, which falsely claimed, this notice serves to confirm that this child is in the care, custody, and control of the Arizona Department of Economic Security. The child has been placed with the following authorized out-of-home care provider. The whereabouts and information about this child is confidential. Now, Isaiah was in my physical custody up until May 4th. So here, they already, on May 3rd, they knew that they were going to take him. And they stated that he was in the authorized out-of-home care provider. Anyways, on May 4th of 2009, I was coerced to attend a team decision meeting, a TDM, at the CPS office. Rhonda Cash, the CPS supervisor, stated to me, she said, because we had brought like this huge bin of medical documents for Isaiah. And she said, Rhonda Cash said, she threw her hands on the desk and she said, I don't care what medical documents you have for Isaiah. I am taking your son because your mother has pissed me off. During the TDM, the team decision-making meeting, an unknown CPS caller made a false 911 call, which resulted in 7 Phoenix police units and approximately 14 officers arriving at the CPS office to specifically detain my mom and myself with false threats of arrest. Whereas simultaneously, CPS worker Jennifer Hagan and 2 police officers went to my mom's home where my son was. They used threats of arrest, coercion, intimidation against my sister to force entry into the home to seize my son Isaiah. Sorry, my nose tickles. And then, violation of Arizona Revised Statutes removal review fraud. CPS did not conduct a removal review, nor did they do an investigation prior to or after the unlawful seizure of Isaiah. Also, CPS did not conduct investigations with the subsequent seizures of my son's 3 brothers, Wilfredo, Josiah, and Jaden. Arizona Ombudsman Citizens Aid Office. May 6, 2009, I reported to the Arizona Ombudsman Citizens Aid Office to Kara Van Heis. The CPS did not conduct a removal review, which generated report number 902457. Okay, so this is in violation of ARS 8-822 3. So, June 5th, 2009, Van Heis covered up my report that CPS did not conduct a removal review. As per her email to Rhonda Cash, CPS states, do you know if anyone told, and then it's blacked out because they blotted it out as, and then they blotted it out again, claims that CPS slipped up and did not do the review as required in violation of ARS 41-1377A. Says, unsupported by an adequate statement of reasons, Van Heis failed to investigate and respond to my report. In violation of ARS 41-1378B, which states, within 30 days of the receipt of the complaint, the ombudsman's aide shall notify the complainant of the decision to investigate or not to investigate the complaint. If the ombudsman citizen's aide decides to not investigate, the ombudsman's citizen's aide shall provide the reasons for not investigating in writing. May 6, 2009, mother also requested a removal review for Isaiah through Wendy Bergsman, Family Advocacy Office. May 14th, 2009, El Juana, I think that's how you say it, Hermanson, Family Advocacy Office denied mother's request for a removal review with the false claim no review of Child Protective Services information and documentation was completed due to the filing of the dependency prior to your request. In violation of ARS 8-828B1, respond to complaints regarding individual cases that involve the child welfare system, and in violation of ARS 8-828B2, on request, immediately review the removal of a child before a petition for dependency is filed. These are, okay, so this is, what it's going to talk about is the denied hearing, that I was denied. Anyways, listen. May 20th, 2009, my name was added to the Central Registry in violation of Arizona law within 16 days after Isaiah was taken. CPS denied me a hearing and predetermined that I was guilty of medical neglect without an investigation, without obtaining Isaiah's medical records, without collaboration from a licensed medical professional, and prior to any court determination. This labeled me as a child abuser for the next 25 years of my life. May 20th, 2009, Carrie Ritzkoff, letter to me, claimed CPS completed its investigation of report number 536136, received on 4/22/2009. CPS has reason to believe you neglected Isaiah in violation of ARS 8-201. The Department of Economic Security plans to enter the following findings in its confidential Century Registry. During the months of April and May 2009, Sarah Johnson neglected Isaiah, age 1, when she failed to provide medical care for a medically fragile child, thereby exposing the child to substantial risk of illness, injury, and or death. If you disagree with this finding, you may ask for a hearing before an administrative law judge at the Office of Administrative Hearings. To do so, you must complete the enclosed form to request a hearing. DES will review the CPS investigation. If DES decides the findings should be entered into the Central Registry, you will have a hearing. It says that in big old black letters. May 22nd, 2009. I requested a hearing before an administrative law judge to address the issue of my name being put in the Central Registry. June 5th, 2009. Ritzkoff denied my request for a hearing before an administrative law judge for the Central Registry issue, as her letter claims. The Department of Economic Security, DES, received your request for a hearing for CPS report number 536136. You are not entitled to a hearing because either you are involved in another legal action involving this neglect finding, or a court has already made a finding about this neglect. In violation of ARS 8-811A2, persons right to a hearing before the entry into the Central Registry pursuant to Section 8-802C9A. June 19th, 2009, Ritzkoff sent me a second letter which claims, "This is to inform you that the finding for CPS report number 536136 dated 2009, April 22nd has been substantiated." CPS perpetuated fraud upon the court after having acquired prior knowledge in December 2008 that mother was providing Isaiah, well, my mom typed this up for me, but knowledge in December 2008 that I was providing Isaiah medical care from more than one pediatrician and neurologist, and records show mother was attending to his needs. CPS, in a fraudulent move and in direct denial of the facts, and with full knowledge that Isaiah's mother, meaning me, obviously, was indeed providing for his medical needs by taking him to multiple pediatricians and specialists, as well as obtained therapy for Isaiah since 2008 through the AZ Early Intervention Program under the Department of Developmental Disabilities, DDD. CPS filed a dependency petition comprised of, I don't know if I'm saying that right, of false allegations of medical neglect against me, which claimed, "The mother is unable to parent due to medical neglect. The mother has refused to take the child to a neurologist or pediatrician and falsely claimed DDD workers refused to work with the family." On October, so this is going to start talking about like my second son, but just kind of just listen. On October 21st, 2010, Amy Cromer, CPS worker, fax cover sheet proved CPS did not obtain Isaiah's medical records while he languished in foster care for 17 and a half months. Sorry, I got a message. December 7th, 2010, December 7th, 2010, minute entry supports CPS did not obtain or submit medical records to the court. Counsel for the mother has concerns with DES caseworkers report, as well as the lack of production of the children's medical records. Exculpatory evidence refutes alleged medical neglect. So, from the beginning, CPS suppressed Isaiah's medical records, which includes Dr. Kevin Chapman's neurological report dated 2009 of June 18th, 2009, taken by foster parent, which confirmed Isaiah did not suffer from seizures, as page 1, paragraph 1 states. Isaiah is now a 15-month-old, non-dominant, handed male who was accompanied today by his foster mother, who has been caring for him for the past month. Isaiah was last seen in this clinic June of 2008. At that time, he has been seizure-free. There was no medical neglect by me, and says there was no medical neglect by mother, and mother was providing Isaiah the medical care and therapy he needed before CPS removed him. And then on this page, it just like wants you to see the supporting exculpatory evidence of no medical neglect. Excuse me. March 5th, 2009, I received a letter from the Arizona Department of Economic Security confirming Isaiah qualified for medical and long-term care through their office. Arizona Long-Term Care System and Access, which is a part of the Arizona Healthcare Cost Containment System, 1 month prior to Isaiah's seizure by CPS. But I'm taking him. March 1st, 2010. After Isaiah was taken by CPS, I received another letter from the Arizona Department of Economic Security that Isaiah again was eligible for health care services under DDD. May 29th, 2009, mother requested Isaiah's records from DDD. August 22nd, 2013, 4 years after my request to DDD for Isaiah's records, I received a letter from David E. Lara, manager, Office of Administrative Review, where they claimed, please be advised that the Division of Developmental Disabilities has no record indicating that Isaiah E. Johnson is or ever was a client of the Division of Developmental Disabilities. Predetermined agenda to terminate my parental rights. The judge claims that my children are adoptable. Within 77 days after CPS seized Isaiah, CPS predetermined to terminate my parental rights to Isaiah as CPS workers searched for an adoptive family. July 20th, 2009. Lane E. Hartley, CPS addendum report to juvenile court states whether Mrs. Gouger would, and this is a friend of the family at the time, that had taken my son, because we didn't want him with any strangers. So it says whether Mrs. Gouger would consider adopting Isaiah. Mrs. Gouger stated that she would consider possibly adopting Isaiah. May 16th, 2011. In defiance of the fact that CPS did not present supporting evidence, no expert witnesses, no authenticated doctor reports to support their allegation of medical neglect against me, Judge Christopher Corey terminated my parental rights to Isaiah and to his brother Wilfredo, and he falsely claimed, says it on page 5, item 3, in May 2009, Isaiah was suffering from seizures at the time Isaiah was removed from his mother's care due to medical neglect. Judge Christopher Corey further stated, termination of the parent-child relationship would benefit the children because these children are adoptable and in an adoptive placement. August 30th, 2012. Assistant Attorney General Daryl Dowdle authored the order to terminate my parental rights to my third son, Josiah, for Judge Brian Ishikawa. A termination of these parental rights would further the plan of adoption. January 6, 2015. Judge Joan Sinclair revealed the administrative decision without a motion from the state/CPS to change the case plan from reunification to severance and adoption of my fourth son, Jaden, in retaliation as a direct result of me pointing out to Joan Sinclair of her fiduciary duty, if I said that right, as a trustee of justice and law. I asked Sinclair, how does the state have evidence to switch the case plan to severance and adoption? And Judge Sinclair responded to me, it's not a matter of evidence, ma'am. We did have this hearing recorded. March 23rd, 2015. I arrived prior to a scheduled court hearing, which began at 11:22. I arrived there at 10:47 in the morning to file a notice of appearance for my mom, Carla, to be as my attorney, in fact, with general durable power of attorney. It was a notice of appearance with POA, power of attorney. Judge Sinclair denied me and my mom entry into the entire court hearing and fraudulently claimed that myself it says the mother, Sarah Johnson, has failed to appear with no good cause, and the court will proceed by default and proceed to terminate mother's parental rights while mother waited locked outside the courtroom. Well, she didn't say that part, but she said, that the mother, Sarah Johnson, has failed to appear with no good cause, and the court will proceed by default. But she did proceed to terminate my parental rights while me and my mom were physically locked outside. They locked the doors. Judicial, I don't know that word. It's MALFEASANCE. Don't judge me. Since the unlawful seizure of Isaiah in 2009, the record is irrefutable that every Arizona judge, I've had 35 judges in my case, committed legal fraud, a crime deemed so severe and fundamentally opposed to the operation of justice when they suppressed, ignored, and struck my preferred exculpatory evidence I submitted to the courts, which includes Isaiah's medical records and home therapy visits from the record, which exonerated me from all of CPS's allegations of medical neglect. As I had 13 court-appointed attorneys refuse to refute CPS's false allegations, refuse to put my exculpatory evidence to the court. Oh, they refused to submit my exculpatory evidence to the court, among other overt and extreme offenses. I filed approximately 88 motions, requests, and notices to the court. Judges granted only 5, ignored 32, denied 21, and struck 8 from the record. The record is irrefutable. Not one Arizona judge ordered CPS to conduct the mandated studies with regards to my 4 sons as follows. A social study in violation of ARS. Here, I'll just show you. Right here. Right here. These are the violations. ARS 8-536. So yeah. And then it says, the record is irrefutable that Arizona judges violate the Code of Federal Regulations, defrauded the federal government through contracts, and fraudulently collected Title E funds because of the unlawful seizure and detainment of my sons, absent abuse and neglect. In violation of 18 U.S.C. 666. Sorry. I rebuke Satan in Jesus' name. Theft or bribery concerning programs receiving federal funds. CPS used willful deception and outright suppression of critical exculpatory evidence, omitted material facts which proved my innocence in order for Arizona to collect federal funds while placing my sons in foster care and then into forced adoptions while denying my family members, especially the maternal grandmother, my mother, Carla Johnson, to accept them into her care. Special note. Contrary to the fact that Arizona judges made reference to and included in their orders CPS workers' reports, which are officially entitled Report to the Juvenile Court for Preliminary Protective Hearing and or Initial Dependency Hearing. Not one of these reports were found in the court case file known as the docket. I obtained the entire docket from the clerk of the court, Michael K. Jeans, May 5th, 2015, which contains documents for all 4 of my sons. May 8th, 2009 to April 15th of 2015. 489 entries, which does not contain one single CPS case or CPS caseworker's report. May 13th, 2009, Judge Kathy Holt failed to order an evaluation of Isaiah, a developmentally disabled child, in violation of ARS 8-242. May 13, 2009, Arizona collected federal funding for placing Isaiah in foster care, who was not seized from his mother, me. Why do I do that? I don't know why I do that. Forgive me. Arizona collected federal funding for placing Isaiah in foster care, who was not seized from his mother for medical neglect, but to prevent abuse or neglect, as per Judge Kathy Holt's order. Part 4 and 5, which claims, based on the court's review of the verified petition and the report of the caseworker dated May 12, 2009, it is ordered continuing the child, Isaiah Emery Johnson, as a temporary ward of the court to prevent abuse or neglect, in violation of, or I'll just show you, because I don't want to say it wrong. This violation right here. In violation of 65 CFR, etc. So, sorry, my hair's bothering me. Kathy Holt also claimed Part 8, the court finds that the Arizona Department of Economic Security has made reasonable efforts to prevent the removal of the child from the home, or that it was reasonable to make no efforts to maintain the child in the home, and that continuing in the home would be contrary to the welfare of the child to be returned or placed in the custody of the parent, or that it was unreasonable to make no efforts to maintain the child in the home. And then here are the other violations. This is what that violated. So, November 17th, 2009, not the first hearing for Wilfredo, which was held October 27th, 2009. Judge Lewis, excuse me, I'm almost done. I'm almost done. I have one more paper after this. Judge Lewis Araneta ordered, page 3, last paragraph claims, it is ordered continuing the child, Wilfredo Palat III, as temporary ward of the court committed to the care, custody, and control of the Arizona Department of Economic Security. And then here's the 2 violations that violated. Okay. And then it says September 23rd, 2011. Judge Peter A. Thompson, page 4, last paragraph, order claims. It is ordered continuing the child, Josiah Johnson, as a temporary ward of the court committed to the care, custody, and control of the Arizona Department of Economic Security. That is in violation of this one. This one right here. Um, April, ouch, sorry, my legs, 9th, 2014, Judge Atrowski's order with regards to my son, Jaden, page 7, paragraph 3, claims, the court finds that there is a need for out-of-home care based upon the information presented, foster care being necessary to protect the child's welfare. May 29th, 2014, Judge Atrowski, page 4, paragraph 7, states, the court finds that the child continues to be dependent according to the statutes. I think it's statutes. And that is in violation of this. Violation of this one right here. Okay, August 5th, 2009. Kathy Holt ordered Isaiah to be placed in an unlicensed kinship care with Sandra Gouger while Arizona collected Title V funds. That is in violation of this violation right here, which states, if the court orders the placement of a child with a specific person or foster care provider, then the child loses Title V eligibility. But they were still collecting it. This is the conclusion. Since the inception of this case in 2008, initiated by the medical malpractice to CPS, unlawful seizure of my first son Isaiah in 2009, and the subsequent seizures of my other 3 sons, my innocence was deprived of my natural right to parent my 4 sons. Had my exculpatory evidence not been fraudulently suppressed from the record, I would have been exonerated of all of CPS's allegations of medical neglect. The civil rights and constitutional violations are so severe and fundamentally opposed to the foundation of our country that the gross injustice of this case alone warrants the immediate investigation of Arizona's CPS, DCS, and judicial system by authorities outside of the state of Arizona. Authorities such as a human trafficking committee and or the Department of Justice, who possesses the empowerment and authority to bring forth criminal charges against state actors for their criminal acts comprised of RICO violations, Stark's Law violations, seditious conspiracy. It says 18 USC, and then it gives that like weird symbol. 2384. Amongst many other violations and conduct an investigation into the medical billing fraud. Me and my family hope to obtain justice, and I have been fighting constantly ever since I was 18 years old for my sons. And I'm going to be 23. Not 23. I'm going to be 32 on December 22nd of this year. Sorry, when I talk about my case, my brain just like scatters, and I don't want to remember all of this. I wish it never happened, but I understand why it happened, and that is so many other children can be saved, so these people, these abominations can be exposed. There are 168 government officials that are documented in my case. There are 35 judges and 13 degenerate court-appointed pretenders. These courts, these family courts, are privately held companies. A lot of our legislators, like senators, Republicans, definitely Democrats, governors, attorney generals, etc., they all participate in the trafficking of these children. They all, not all of them, but a good majority of them do. These children that are put in foster care are used for organ harvesting, adrenochrome. They're obviously used for profit. They are used for satanic rituals. Legislators here in Arizona actually have their own group homes. And Governor Ducey and the Attorney General Mark Brnovich are at the top of my list that participated in trafficking my 4 sons. I am not going away. I'm never going to go away until God says that it's done. These people, all of you that participated in taking my children, my prayers are going up to God and so many others, and our prayers are powerful against you. I will continue to expose who you are. I will continue to expose the crimes, the fraud, the treason, the RICO that you have committed in these privately held courts. I'm not going anywhere. I am one of your worst nightmares in the state of Arizona. Melissa Deagle is another. Carla Johnson is another. Shannon Henderson is another. And the list is going on and on and on. And we are covered in the blood of Jesus, and no weapon formed against us shall prosper. And God is coming for you. What has happened in darkness, everything that you have done, is coming out. It's already coming out. And everything that you have sown into this world, you're going to reap it, and it's coming back on you big time. And I am telling you right now, with this fraud, this treason, and this RICO, and the crimes against humanity, your punishment is probably going to be death. And Guantanamo Bay is calling your name, and I know God has made a home for you there if he does not take you out sooner. Now, I am not in control of what God does, but I do pray. I do pray for your destruction because of what you have done to these families. Sure, I have prayed that you guys would repent and turn from your wicked ways, but it has gone way beyond that. I don't pray for mercy on you. I pray for the swift move of the wrath of God and the judgment of Jesus Christ. That God sends out that same angel that went and killed 185,000, I believe it was in the Bible. That same angel I put on assignment to go after all of you abominations in the land, and God knows which are abominations and which aren't. I'm not going anywhere. For it is the Lord my God who goes before me to fight for me, to give me the victory, to give these other moms and dads, aunts and uncles and grandparents the victory. You need to fear. You need to be afraid. Because everything that's happening right now, all the exposure, God's been listening to his people. He's heard every tear. He's heard and seen all the heartache and destruction of his people. And he's coming for you. The clock is ticking, and you never know what day he's going to claim you. To all of you survivors out there, I know God is so pleased with you because you are fighting for his children. You are fighting against this evil. You are more than conquerors. You are all covered in the blood of Jesus, and no weapon formed against you shall prosper. And I pray that God continues to put laborers in our pathway, and that he orchestrates our days to line up with his will, and that he parts the Red Sea for us, and he disintegrates and abolishes every evil that stands in our way of our victories, of the harvest that he has for us, in Jesus' name. Stay strong, parents. Stay in the fight. It's okay to have weak days. It's okay. The most important thing is that you get back up. God bless you all. And thank you.